Hi, my name is Nikki and today I'll be providing you with information to help you with your separation and parenting matters. I have also been through a separation and divorce and know what you are going through. There is light at the end of the tunnel and the separation will make you stronger. I was a family dispute resolution practitioner for 3.5 years and I will provide more information about this during the session. I hope this information helps you and keeps you out of the courts. Separation is hard on the parents, but more so for the children. The decisions you make now may have important consequences later. So don't make decisions in the heat of the moment, and most importantly, stay calm. There is life after separation. Children are resilient as long as there are no safety concerns. You don't have to be the best friends with the other parent, but be respectful. Don't spend years fighting over the kids or silly issues because in the long run, nobody wins. Pick your battles. Find a way to move on and become the best person and the best parent you can be. You need to be able to communicate with the other parent. You probably split because you didn't communicate, so you will need to learn to work together to parent the kids. This is certainly hard, but it can be done. You are both still the parents. Some parties seek counselling to work on their communication. Some use a communication book, which I don't think helps the issues. Some organise a talk during the week regularly. Remember, it is best to talk when the children are not in earshot. Sometimes it just takes time, but then if too much time has lapsed and there has been too much fighting, then the damage is harder to fix. You need to remember, kids model our behaviour. You may be experiencing shock or anger, and the other parent may be moving on. Everyone moves at different stages. Talking to family, friends, or a counsellor is helpful, but remember, everyone's experience is different to yours. Some parents may need to seek legal advice. It shouldn't be about sticking it to the other parent, but knowing what is fair and for the best interest of the children. If you do seek legal advice at any time, ask about the fees up front. There are community legal centres in Western Australia. You can find further information from the National Association of Community Legal Centres, including Legal Aid. A woman can use the name she had on a birth certificate, her maiden name, at any time. If a man denies that he is the father of the children, a medical test can be used to establish the paternity. This will need to be ordered by the court. If he still refuses, then the court may presume he is the father based on his refusal. There is no 50-50 property settlement rule, and I discuss this further in my property session. If you have safety concerns and need to get personal items that you left behind, you can ask the police to accompany you. If you are married, a divorce may automatically render your existing will invalid. If you were married or de facto, a separation does not automatically revoke a will. You may wish to amend your existing will or make a new one. It is always preferable to reach an agreement between yourselves. If you need assistance, you can attend counselling, mediation, seek legal advice, or attend the court as the last resort. If you have an order in place that the children are to live, contact, or spend time with you and the other parent has refused to let this happen, then you can apply for a recovery order with the court. A recovery order can then authorise a police officer to take appropriate action to find, recover, and deliver a child to you. If you want to prevent an Australian passport being issued for a child, you can lodge a child alert request at any Australian passport office or apply to the court for a child alert order. A child alert request warns the Department of Foreign Affairs and Trade that a person may apply for an Australian passport for a child without proper and legal consent. If a child alert is in force and an application for an Australian passport is received for a child, you will be notified by the Department of Foreign Affairs and Trade. A child alert request made at an Australian passport office is valid for 12 months. A court-ordered child alert stays in force until a child turns 18 or as directed by the court. You will need to provide with the request form a certified copy of any court order reflecting parental responsibility for the child and an accompanying statement if necessary. A child alert does not stop a child departing Australia on a valid Australian or foreign passport and does not cover passports issued by other countries. If you think a passport may be issued for a child in another country, contact the embassy of that country. If there is a possibility or threat that a child may be removed from Australia on a current passport, you can apply to the court for orders. The court may order the delivery of a child's or accompanying adult's passport to the court. If ordered, the person in possession of the child's passport must deliver it to the court. The court will keep it for the amount of time detailed in the court order or until further ordered of the court. If you have concerns about the other parent removing the child from Australia without your consent, you can place the child's name on the airport watch list. This is to be used for matters where there is an actual fear that the child may be removed from the Commonwealth of Australia. You are required to obtain a court order or an application for an immediate order that directs the Australian Federal Police to place the name of the child on the airport watch list. This watch list will also affect you travelling with the child, so seeking legal advice is very important to understand the consequences, and also there is specific wording required by the Australian Federal Police. If you consent to a child travelling out of Australia in the future or wish to take a child out of Australia yourself, you must apply to the court before you travel to have the child's name removed from the airport watch list. If you fail to do so, a child may be prevented from leaving irrespective of who they are travelling with. The Australian Federal Police cannot remove the child's name from the list without an order of the court. If you are planning on getting a divorce, you need to be separated for 1 year. The family law in Australia is based on a no-fault principle. You can apply for a divorce individually or together. The divorce becomes final 1 month and 1 day after it is made. If there are children under 18 years, the court must be satisfied that arrangements have been made. You don't need to have finalised everything, but there are no safety concerns. Once the divorce order has become final, you have 12 months to start proceedings for property settlement. If you were in a de facto relationship, you have 2 years from the date of your separation to finalise property settlement. If you do not complete the property settlement by the time frames, you will need to apply to the court for an extension of time. This is not always granted, and you will need to provide reasons why you have not finalised the settlement. You do not need to be divorced before you can make orders about the care of your children. If you were married for less than 2 years, you will need to attend compulsory counselling where a counsellor will complete a form that is required by the court. Both parents are obliged to provide financial support for children until the children reach 18 years, are married or are adopted. Financial support may be claimed through the court for children over 18 years to enable the children to complete their education or if they are mentally or physically disabled. Child support is a legal requirement even if you are not spending time with the children. Some parents wish to make their own agreement, some have a child support assessment, and some have the child support agency to collect on their behalf. It is what works best for you. I would suggest you contact the child support agency for further information. You can call anonymously, or the child support agency has a helpful website. One party may wish to apply for spousal maintenance. This is where a payment is made by one spouse to the other because of significant differences in their income. There is no formula, but a number of factors that the court takes into account, such as your age and health, income, financial resources, your ability to work, etc. Applications for spousal maintenance, if you are a party to a marriage, must be made within 12 months of your divorce becoming final. Applications for de facto spouse maintenance must be made within 2 years of the breakdown of your de facto relationship. If you do not apply within these time limits, you will require special permission from the court, and this is not always granted. The Family Law Act has undergone some changes. The law now requires separated families who have a dispute about children to make a genuine effort to try to sort it out through family dispute resolution. This is a requirement if you want to file an application with a family law court and if you wish to seek changes to an existing parenting order. There are exceptions such as cases involving family violence, child abuse or urgency. The benefits of mediation is that you have the responsibility for making your own decisions about your own lives. Mediation can be conducted in private without lawyers, therefore saving you money and further stress. The aim of mediation is that an impartial third party helps by assisting you to isolate issues and to explore options for settling the dispute. A family dispute resolution practitioner is impartial and cannot give legal or financial advice, but can provide information and help you to resolve the disputes. They are there to help you. The Family Law Act still requires a court to regard the best interests of the child as the most important thing when it is making a parenting order. The court must take into account the benefit to the child of having a meaningful relationship with both his or her parents and the need to protect the child from physical or psychological harm from being subjected to or exposed to abuse, neglect, or family violence. A presumption that both parents have equal shared parental responsibility. This doesn't mean equal time, it means both parents have an equal role in making decisions about major long-term issues that affect the children, such as schooling and healthcare. This presumption does not apply where a parent has engaged in family violence. Substantial and significant time refers to a child spending time with both parents on a mixture of weekends, holidays, and regular days. If you wish to move to another town, state, or country, and this will affect the other parent's time with the children, or if you wish to change schools, you are required to discuss this with the other parent. If the other parent doesn't agree, then you will need to try family dispute resolution, and if no agreement, attend the court. If you move addresses or change schools without agreement or a court order, a court may require you to return the child until it is considered the case. If there is an order in place not allowing the move, you will be breaking the order and the other parent can apply to enforce the current order. The magistrates and lawyers do not know your children or what is best for them, only you do. So it is important that you work together for the best interests of the children. You can attend family dispute resolution even if you have a violence restraining order against you. You need to make sure it states a save and accept clause as defined in Section 51 of the Family Court Act 1997, or the newer violence restraining orders have Part A, B and C, stating that the person can attend family dispute resolution as defined in the Family Law Act 1975 and Family Court Act 1997. Some agencies do not work with parties who have a VRO, so you would need to check with them first. If there is no agreement in family dispute resolution, you may be issued with a certificate Section 60I of the Family Law Act 1975, which is basically your ticket into the court. You will need to complete a Form 1 application form to attend the court. If you do reach an agreement, you will receive a parenting plan. If you wish to make this legal, you will need to complete a Form 11 application for consent orders. Some parents wish for the agreement to be legal and some don't. Parenting plans are written agreements signed and dated by both parents and setting out the children's arrangements. They are a good faith agreement, not legally binding, and are not registered with the court. Consent orders are legally binding. You can have your parenting plan drawn up as a consent order. If you don't have consent orders, then the police usually will not intervene and advise you to attend mediation. Parenting plans and consent orders can set out where the children shall live and who will take care of them, when they will spend time with the other parent, who has parental responsibility, transportation, communication, special occasions such as Christmas, birthdays and school holidays, the care, welfare and development of the children. You can really put whatever you want into the agreement. Parties can attend family dispute resolution if already commenced court proceedings. The court would rather you resolve the dispute outside of the court. You can find a family dispute resolution agency at the Family Relationships online website. All agencies have a different process and a fee may be incurred. The Family Court of Western Australia website is very helpful for information. I hope this information has been helpful.